Welcome to Chapter 10, The American Legal System and the Courts. In this chapter, we learn about the dual system of state and federal courts, the role of law in democratic societies, the constitutional basis for the American judicial system, the relationship of citizens to courts in America, the notion of law and the role that it plays in a democratic society, and then the Supreme Court and the politics surrounding it. Article 3 of the Constitution establishes the judicial branch. As we know from previous lessons, the founders left quite a bit of discretion to Congress to finalize the establishment and creation of the judicial branch. The Constitution itself merely sets forth the establishment for the Supreme Court. It leaves Congress significant discretion to determine the shape and the structure of the federal judiciary. Even the number of Supreme Court justices is left to Congress. At one point in time, we had 6 Supreme Court justices. Currently, there are 9 Supreme Court justices. The role of law in democratic societies. 4 very important points and 4 provisions that law provide. Laws provide security. They provide predictability. They provide us with a means to resolve conflict. And they also enforce conformity to society's values. That's to keep us in good behavior. The American legal system is characterized by an adversarial system instead of an inquisitorial system. There are 2 sides represented in court. There is the plaintiff and the defendant in a civil action. Both of those are adversaries to one another. Another characteristic of the American legal tradition is that it's primarily based on common law, that's law made by judges and precedent, instead of civil law, which is codified and usually created by legislatures. As we probably all know, and the TV commercials will verify this, Americans are extremely litigious. Turn on your TV, you will see attorney ads, and you will hear attorneys sometimes be the subject of numerous jokes, such as ambulance chaser jokes and things of that nature. Common law. The American system is characterized by common law. It's derived from England and part of the English law tradition. It combines judicial precedent or decisions made by judges with custom. It is not codified. In other words, it is not in the form of a statute. Precedents are how judges rule in a common law system. Common law, as I mentioned earlier, in America, is seen as an adversarial system, a contest between 2 opposing parties before a judge who moderates and listens to the evidence and ensures that the 2 parties play by the rule. Of course, in the U.S., common law is not the only form of law that we have. Many states now have gone to civil law, and our federal law is mainly civil law at this point. It has been codified. The legislature has created statutes that determine the law as to certain areas, be it an environmental area, energy, criminal, civil. It's based on a comprehensive legal code. With civil law, the judge's role is to establish the facts of the case and to apply the provisions of the applicable code. There are 4 basic kinds of law. There are substantive laws, which guarantee outcomes, procedural laws, which guarantee or seek to guarantee fair procedures, civil laws, and criminal laws. Sources of law. Constitution provides numerous sources for our common day laws. Then, of course, we have the common law based on English precedent, statutory laws, administrative laws, laws made by administrative agencies, such as the Department of Agriculture when they implemented their new rule on importation of dogs. Then there are executive orders issued by the President. Judicial review. Judicial review is one of those checks and balances that is not provided in the Constitution, but it's been created by the Supreme Court. Judicial review acts to review and ensure compliance with the Constitution. It ensures compliance by the executive branch as well as the legislative branch.